Hey everyone, and welcome back. In previous videos, we've looked at the structure of the federal court system in the United States. In this video, we're going to look at how courts make decisions and resolve legal disputes. Our idealized image of the courts paints judges as neutral and detached arbiters, impartially and methodically interpreting legal statutes and precedents with a focus on rationality and objectivity. Judges are seen as embodying the principles of justice and are unswayed by personal beliefs or external pressures, meticulously analyzing the facts presented, applying relevant laws, and reaching decisions based solely on legal reasoning. But how accurate is that image? Certainly, legal factors like precedent and statutory interpretation play an important role. But other factors like judicial processes and internal court dynamics, broadly grouped under the label of institutional factors, also play a role. So too do extra-legal factors like public opinion or lobbying. And the judge's individual political orientation and judicial philosophies can also influence decision-making. So let's take a look at how these various factors play out in a bit more detail. And let's start with the legal factors that influence judicial decisions. The first, and arguably one of the most important, is the concept of stare decisis, a Latin term meaning to stand by things decided. Stare decisis is a fundamental principle in the common law system where judges are expected to follow the precedent set in previous court decisions. This ensures consistency and predictability in the law. When the court faces a case similar to one previously decided, it generally follows the reasoning and outcome of the earlier decision unless there's a strong reason to deviate. Often, judges need to interpret statutes or laws passed by legislatures and apply them to specific cases. This involves determining the legislature's intent, understanding the context in which the law was written, and applying the law to the facts of the case. But even here, different judges might use different methods of interpretation, with some judges favoring textualism, focusing on the text of the law itself, with others employing purposivism, which emphasizes the purpose behind the law, and others still relying on pragmatism, looking at the practical consequences of the decision. And in cases involving constitutional issues, judges must interpret the Constitution, which often involves a broader, more complex legal reasoning. This can include evaluating the historical context of the Constitution, its amendments, and the framers' intentions, as well as considering the evolving societal and moral standards. Finally, there are other legal principles and doctrines that judges have to consider in the decision-making process. This can include principles of equity, which emphasize fairness and justice in decisions, and international law where applicable. Judges also consider the doctrine of proportionality, which ensures that legal decisions are proportionate to the issues at hand, and the principle of legality, which ensures that decisions adhere to the law. A variety of institutional factors can also shape judicial decision-making. The structure and hierarchy within a court can significantly influence decision-making. In appellate and higher courts like the Supreme Court, the decision-making process often involves collaboration and negotiation among the judges or justices. The Chief Justice or Senior Judge often plays a role in setting agendas, assigning opinion writing, and sometimes influencing the direction of legal reasoning. The specific procedures and rules that govern court proceedings, such as how cases are selected for review, rules for submitting and considering briefs and oral arguments, and the procedures used for internal deliberation and drafting of opinions, can also shape judicial decision-making. For example, in the U.S. Supreme Court, the rule of 4 requires 4 justices to agree to grant a writ of certiorari, which determines which cases will be heard. Each court has its own traditions, institutional norms, and culture, which can influence judicial behavior. Examples might include unwritten rules about deference to senior judges, norms about assigning dissenting or concurring opinions, and the court's historical approaches to certain legal issues or types of cases. In appellate courts where judges sit in panels, the composition of a panel can affect decisions. Studies have shown that the ideological leanings of panel members can influence a judge's decision, with judges tending to moderate their positions when sitting with colleagues of different ideological persuasions. And finally, the availability of resources, including research support, clerks, and administrative staff, can also impact the quality and depth of judicial analysis. Courts with more resources can engage in more thorough legal research and deliberation, while courts with fewer resources may have to cut these kinds of processes short. A variety of extra-legal factors can supplement the legal and institutional factors in decision-making. First, while we tend to think of judges as being immune from social pressure, in reality, judges, particularly in higher courts, can be influenced by prevailing public opinion. Societal attitudes and trends can subtly influence a judge's interpretations and decisions, especially on contentious issues. This is particularly true in cases that have significant societal impacts or are highly publicized. Various external actors, such as political parties, interest groups, and non-governmental organizations, can influence judicial decision-making. They may exert pressure through public campaigns or lobbying efforts or other forms of advocacy, aiming to sway judicial attitudes or raise awareness about a specific aspect of a case. One of the most common and direct ways they do this is by filing amicus curiae briefs, Latin for friend of the court. Amicus briefs are submissions by non-parties to a case who have an interest in the outcome of the matter. These briefs provide additional perspectives and expert information that can inform judges and potentially influence their decisions. They are particularly common in cases involving significant legal, political, or social issues at the Supreme Court, where it's not uncommon for cases to receive dozens of amicus briefs. The media's portrayal of legal issues and cases can also impact judicial decision-making. Extensive media coverage can raise the profile of a case, potentially influencing public opinion and indirectly exerting pressure on the judiciary. Media narratives can frame issues in particular ways, influencing how cases are perceived both publicly and within the judiciary. And finally, the broader political environment and the relationship between the judiciary and the other branches of government can influence judicial decisions. For example, judges may be conscious of how their decisions might affect or be perceived by the legislative or executive branches, particularly in cases with significant political implications. And finally, the judges themselves, their personal values and beliefs, can shape judicial decision-making. A judge's personal background and experiences, values, and beliefs can influence their decision-making. While judges strive for objectivity, their understanding and interpretation of the law are invariably filtered through their personal lenses, which can impact their rulings, especially in cases where the law is open to interpretation. For example, a judge with a background in corporate law may approach business-related cases differently than one with a background in civil rights law. More broadly, a judge's political and ideological leanings can affect their decision-making. For instance, a judge with conservative leanings might prioritize law and order or property rights, while a more liberal judge might focus on individual freedoms and social justice. These leanings can influence how judges interpret laws, view the role of the judiciary, and approach issues like criminal justice, civil rights, and economic regulation. Decisions may also be impacted by judicial philosophies, the broad frameworks that judges use to interpret the Constitution, statutes, and other legal texts. There are three broad political philosophies common in the United States today. Originalism posits that the Constitution should be interpreted based on the original understanding of the authors at the time it was written. Originalists strive to uphold what they perceive as the original intent of the framers, which can lead to more conservative rulings in some cases. Textualists focus on the literal wording of legal texts, such as statutes and the Constitution, without considering external factors like the intent of the legislature or broader societal implications. This approach often leads to strict interpretations of legal texts. And finally, living constitutionalism holds that the Constitution is a dynamic document that should be interpreted in the context of the contemporary society and its values. This approach tends to lead to a more progressive interpretation and adaptability to changing social norms. These various factors, the legal, institutional, extra-legal, and personal factors that influence judicial decision-making, are combined in various ways to develop theoretical models to explain judicial decision-making. Legal formalism, sometimes also called the legal model, posits that judges apply legal rules and principles mechanically and objectively with little personal influence or discretion. From this perspective, law is a complete and coherent system where every judicial question has a right answer discoverable through logical reasoning and the application of legal principles. In contrast, legal realism argues that the law is not a fixed set of rules, but instead is subject to personal interpretation of judges. According to this theory, judicial decisions are influenced by the judge's personal beliefs, values, and experiences, as well as social, economic, and political conditions. Legal realists argue that the law is unequally applied and often reflects the interests of those in power. Institutionalism focuses on the institutional context of judicial decision-making. It suggests that decisions are not just about legal rules or judges' preferences, but are also shaped by the structures and norms of judicial institutions themselves, the relationships among judges, procedural rules, and the court's interactions with the other branches of government, as well as society more broadly. The strategic model posits that judges are strategic actors who make decisions not only based on the law or their personal preferences, but also considering the preferences of other relevant actors like other judges, the public, or the other political branches, and the potential consequences of their decisions. The strategic model emphasizes the role of negotiation, compromise, and strategy, particularly in collegial courts where decisions are made collectively. And finally, the attitudinal model maintains that judicial decisions are primarily the result of judges' personal attitudes and policy preferences. According to this theory, legal rules and principles are often vague and open to interpretation, allowing judges to decide cases in ways that align with their ideological leanings and policy preferences. Each of these theories offers a different perspective on judicial decision-making, highlighting the various factors that can influence how judges interpret and apply the laws. In practice, a combination of these factors likely influences judicial decisions, with the relative impact of each factor varying depending upon the specific context and nature of the case. Each of these theories offers a different perspective on judicial decision-making, highlighting various factors that can influence how judges interpret and apply the law. In practice, a combination of these factors likely influences judicial decisions, with the relative impact of each factor varying based on the specific context and nature of the case. Finally, we can also differentiate between judicial activism and judicial restraint as two opposing philosophies or approaches in judicial decision-making, particularly in the context of constitutional interpretation and the role of courts in society. Judicial activism refers to a philosophy where judges are more willing to take bold policy decisions, even if it means overturning legislative acts or prior judicial rulings. Activist judges are often seen as going beyond the text of the Constitution or statutes to consider broad societal implications, moral values, or the needs of contemporary society. Judicial activists frequently offer a broader interpretation of the Constitution, often in line with current societal values, and are willing to use judicial power to achieve social change, especially in areas where the other branches of government may be inactive. But critics argue that judicial activism oversteps the intended role of the judiciary, infringing on the roles of the legislative and executive branches, and undermines democratic principles by allowing unelected judges to make policy decisions. Judicial restraint, by contrast, is a philosophy where judges tend to defer to the decisions of the elected branches of government unless there's a clear violation of the Constitution. Judges exercising judicial restraint avoid making broad policy decisions and focus on applying existing laws and precedents. They're generally reluctant to declare legislative and executive actions unconstitutional and maintain a narrower interpretation of the Constitution closely tied to the original text and intent. This position is often associated with upholding the status quo and limiting the power of the judiciary. But critics of judicial restraint argue that it can lead to a perpetuation of injustices and social inequalities, as it may prevent the judiciary from intervening in cases where legislative or executive actions are morally or ethically questionable, yet not explicitly unconstitutional. And in practice, the distinction between judicial activism and restraint is not always clear-cut, as judges may not consistently adhere to one philosophy in all cases. Furthermore, perceptions of judicial activism or restraint often depend on one's political and ideological viewpoints. But that's it for now. Please leave any questions you have in the comments section below, and thanks for watching.